Today, we're going to review the brand new Hawaii Commercial Purchase and Sale Agreement, or PSA, which will be released for statewide use on November 1st, 2025 by the Hawaii Association of REALTORS in conjunction with CCIM Hawaii. I'll be joined in just a moment by two prominent Hawaii attorneys who were instrumental in the redrafting of the PSA to share their insights and some background. If you are a buyer, seller, or broker of commercial real estate, this is information that you must have. My name is Patrick O'Neill, chair of the Standard Forms Committee for the Hawaii Association of Realtors. I'm also the principal broker owner of O'Neill Group Commercial and Luxury Homes International in Honolulu, Hawaii. First, like to express my deep gratitude and appreciation for all the members that participated on the Commercial PSA subcommittee. On the screen right now, you'll see some of the brokers and members of CCIM. And on this screen are the non-brokers. And I especially want to thank Ryan Gilbert, asset manager at Weinberg Foundation, for all the comments and suggestions from Ryan and his team, and also Michael Carroll, who is an attorney and a top litigator in Hawaii. Michael is also a partner at Lung, Rose, Voss, and Wagneld. His insights were fantastic, and he also helped redraft several sections in the new Commercial PSA. But I especially want to thank these two ladies. Lauren Sharkey is an attorney, director, and shareholder at Case Lombardi. Sara Tsukamoto Strona is an attorney and director at Starn O'Toole Marcus Fisher. They were instrumental in redrafting several sections, and they've agreed to be here today, make some time to share their insights and background on the PSA. Ladies, would you join me at this time? Great. Thank you both very much for being here today. I just wanted to start. We had this conversation several times at the committee level and subsequently the three of us. It's very important to recognize that the standard Commercial PSA is not a substitute for expertise in commercial real estate, nor is it a substitute for professional and legal advice. And Sara, could you just touch on that for a moment?
Sure. So while this new PSA is really intended to be a great starting point for many transactions, it is not a one-size-fits-all tool. And it's very important to know that there may be a need to customize it or add a special terms addendum or seek the advice of legal counsel to really help guide the parties in order to make sure that the PSA really works for their specific transaction.
Great, thank you. And Lauren, I know, I think we are all surprised at how often the standard PSA is being used. Weinberg, which has been very active over the last 2 years, said the majority of the purchases they've seen have been coming in on the standard PSA. What has your experience been with the existing PSA? How did you handle that? And then will there be any change using the new version?
Yes, I think the intent was to bring the existing form into something more current based upon what the customary practice is now. So in the past, I would use the form, but then need to really attach a pretty comprehensive special terms addendum to try to address some of the differences in what the form had versus what people do today. So the expectation is hopefully that will be less and there'll be a greater use of the form.
Okay, great. Thanks for that. All right, well, let's jump into the changes on the Commercial PSA. So just want to start here. The document has been completely redrafted in every way. And it's important, if you're using the Commercial PSA, that you go through everything. We're going to highlight some of the big changes today, but not everything that's here. We have a disclaimer. Please read that in the description below. And I want to emphasize, nothing said today by the presenters should be considered legal advice. And if you're a licensee, please check with your principal broker and legal representatives for your company's policies and procedures. The first thing you'll notice is page 1 is completely reformatted. On the left-hand side, we have the new PSA. On the right-hand side, the old one. By the way, last time this was revised was in 2017. But we've taken off a lot of that personal information that rarely was completed by anyone. And we've also retooled page 11, now contains all the information for the brokerage firms, including agency disclosure. Page 12 has become the signatory page and an addenda section. We'll look at those in detail in a moment. But let's start with Section A. The first thing that we have done is we've moved up the expiration of the PSA to page 1. Previously, you had to scroll through to page 3 to find that. We've also simplified the initial deposit and additional deposit schedule. And you can see initial deposit tied to X business days after acceptance date, additional deposit X business days after the end of the B1 due diligence period. Lauren, let me start with you. Both of these words, initial deposit, additional deposit, are capitalized. Can you explain what that means and what the proper use is going forward?
The capitalization indicates to people that there is a specific definition for those words, and they are intended to be used consistently throughout the document. So if you see words that are initial capitalized, you should understand that that's expected to show up later. And so wherever you see that, you should try to refer back to where it was initially defined so that you can make sure that you understand how it's being applied in that particular section.
Thank you for that. So important in addenda, special terms, amendments heading into the future. Okay, this is a brand new section, B1, the due diligence period. This replaces the J2 inspection period, again, using more common modern day parlance. And I just want to point out that the due diligence period is not just to inspect the physical property, but everything, including financial. There's a big laundry list of different things in here. And we re-emphasize again and again that the buyer is being provided this opportunity and they are relying solely on their own due diligence investigation. Sara, can you touch on this just a moment and the importance of that?
Sure. So this is really something that reflects what we see in most modern commercial transactions, where the buyer is really responsible for doing their own due diligence. And like Patrick said, that includes not just the physical condition of the property, but everything from title to survey to environmental, zoning, etc. And so it's really the buyer's opportunity to do a full, thorough inspection of the property and to receive certain due diligence materials from the seller to help them do that. And the disclaimer here in bold is really meant to give the parties clarity on whose responsibility it is to conduct that investigation. It's really the buyer's. And the seller is disclaiming any warranties or statements meant to induce the buyer to enter into the transaction or to close. And so we thought it was really important to keep that disclaimer in there.
Great. Okay, thank you for that. And then I just want to point this out. This is at the bottom of the due diligence period, but the contingencies. So if a buyer does not exercise the right to terminate prior to the expiration of the period, the buyer will have waived this contingency. Lauren, we find this throughout the document on the right to terminate under O-2. Could you just talk a little bit about this and the importance of tracking those timelines?
Yes, so the idea was that there are different contingencies or different periods throughout the document, and we wanted to be essentially triggered off of the due diligence period as the date that the buyer has to conduct their investigation. And so even though while maybe other sections may have other dates, the idea is that the buyer needs to be very clear that the due diligence period expiration date is very substantive and significant in the agreement as a whole. And if they don't exercise their right to terminate, then they are bound to the contract and subject to remedies if they try to terminate after that date.
Great, thank you for that. This is a new section, B2, delivery of due diligence materials, and this replaces the previous J1, which was strangely titled inspection of property. But we have this here. We're talking about due diligence materials. And then this is an important term in here. So the seller needs to deliver documents that are to seller's actual knowledge, in existence, and in seller's possession or control as of the acceptance date. Sara, can you explain what that means?
Sure. So there are generally two types of knowledge. There's actual knowledge, which is knowledge that you actually have in your head. And there's also constructive knowledge, which is knowledge that you should have had based on the circumstances or based on your relationship with other parties. So one common example of constructive knowledge is if you had a property manager and that property manager knew something about the property, that they should have communicated to you as the owner. That could be one example of constructive knowledge. So we tried to narrow down the scope of what the seller would be required to provide by limiting it to just what the seller actually knows is in their possession or control. So if the seller has a property manager and the seller knows that the property manager does have a specific document or item that is required to be provided, that would be actual knowledge that the item is in the seller's possession or control because the property manager functions as an agent of the seller. If there's some document or let's say a notice of violation or a letter or other communication that the property manager received but never notified the seller about, that would likely not be something that the seller would be would actually know about, and that would be excluded from the list. Similarly, if there's an item that is not in anybody's possession or control, either the sellers or their agents or property managers, that item would also be excluded from the list of due diligence materials.
Hi, it's Patrick. If you're enjoying this content, please do give us a thumbs up below and be sure to subscribe. Thank you. Great, thank you. And I know that sometimes every single box here is checked and buyers agents are saying, give me those documents. But if they're not in the seller's possession or the actual knowledge, those do not need to be provided under this provision. We've also added a couple of new boxes to check down here. And one of them down at the bottom is notices of violation or notices of order from governmental authorities. Lauren, can you explain what that is and some common examples?
Yes, so the general list conceptually is that we wanted to identify things that could apply to the property. It doesn't mean that it always applies or that it applies specifically to the property. And so the notice of violation or notice of order from governmental authorities, we typically see that where there may be something that applies to improvements. If there is a violation where you didn't get where the seller didn't get a building permit that was applicable to an improvement, and there's some complaint, and then the CPP can issue, or the county can issue a notice of violation, and it provides for corrective measures. And then after that, then there would be fines if it's not addressed. So it's important for the parties to understand if there are any violations currently in existence and applicable to the property. So that's why we specifically called that out, because that's something typically important to the buyer. And it usually is just focused on an issuance of something writing that's issued from the city or the federal government if it deals with environmental matters. That's another area in which we've seen notices of violations.
Okay, great. Thank you for the explanation. I'll point out that we have deleted the word scheduled closing date. This is now just closing date. And by the way, if you are responsible for your company's standard addenda, be sure you're going in, changing the references and the cross-references both in the words and in the identifications. Looking at the unilateral right to extend. Now, this is a big change. And this comes out of what we've been using on the residential side, which has been really nice. And in this newly done unilateral right to extend, whatever the extension period is, it can be used by either party until the full amount of that extension is used. Under the existing PSA, if either party uses any portion of this unilateral right, then the other party has no ability. So, for example, if this is 15 days and party A uses 5 days, either party can use the remaining 10-day balance. And Sarah, can you talk a little bit about this and why the change happened?
Sure. So this change was really in reaction to seeing that some parties were sort of gaming this provision and using it defensively by exercising the right to extend for maybe 1 or 2 days immediately in order to foreclose the other party's opportunity to use the rest of the extension period. And so we just thought that this setup was a lot more fair and reasonable, that either party should have the right to use that full period if it's not been used previously. And so the new change seems a lot more consistent with what everyone would think would be kind of the normal course of a 15-day period or whatever the period is.
Yeah. And from a practical use, oftentimes we just need to extend maybe 2 or 3 days. It might be financing or documents being mailed in. And we would just extend this whole period because there'd be no ability to go back if you needed 1 extra day or so. So this is a very good change. Section D in the financing, we hear the term used, commercially reasonable efforts, and we see it here. Buyers obligated to use buyers' commercially reasonable efforts to obtain the loan. Lauren, can you explain what that word means, or those words?
Yeah. Right. So the expectation is this contract is addressing commercial property, and the idea is that commercially reasonable efforts is something from a business perspective, what would be anticipated or expected in the commercial context versus the other efforts could be something like all efforts or best efforts. And so there is more of a determination as to whether it's everything and anything the buyer could do versus what's reasonable from a business context. So for example, if you had financing and the lender wouldn't approve it unless the buyer principal personally guaranteed the loan, that may not be in this particular situation to be commercially reasonable efforts, because that would be something more akin to all efforts. So it's not intended for a buyer to have to do everything and anything to obtain the loan, but what's reasonable in the commercial practice.
Great. Okay, thank you. Yeah, we see this appear multiple times. We've also added identification where we can in various sections, such as the A and B, for easy reference for amendments or special terms. And then this is a change that came from the Mortgage Bankers Association and some of the commercial lenders in town. Final loan approval letter no later than X days before the closing date. Previously, this was tied to the inspection period, and I think that's a more convenient way to look at this. When we go down here, should buyer fail to satisfy any obligations under this section, the seller may terminate pursuant to paragraph O-3, which is a brand new default provision. We'll take a look at that in just a moment. When we get to title objections, it's kind of an interesting section here. Now, if there are title objections, the buyer will have X days from delivery of the title report to send any written notices of objections. Previously, this was also tied to the inspection period. But here is the important thing to understand. The termination is tied to the due diligence period. And Sarah, can you talk just a little bit about this and how this interacts?
Sure. So we had sort of gone back and forth about whether there should be a separate title review period, because the feedback we received is that oftentimes the title reports are delayed or are not received until very late into the due diligence period. Ultimately, we decided it was a lot cleaner and simpler to just keep that termination right tied to the due diligence period expiration date. And so what that means is that it is possible that the title report will come very late in that due diligence period, and that 15-day or X day period will actually be cut off by that due diligence period expiration date. In other words, the 15 days might run beyond that due diligence period expiration date. And so what that means from the buyer's perspective is it's very important to keep track of those dates and know that even if you receive that title report 10 days before the due diligence period expires, you will not get that full 15 days. And so if you feel that you need that full 15 days, it's important to reach out proactively to the seller and negotiate an extension to make sure that your client has adequate time to review and to provide the title objections.
Great, thank you. Vesting and tenancy. So we made a few modifications here, really, so that it will line up with the assignment provision in S-5, which we'll look at in a moment. Previously, these two could be in conflict. Under the assessments, there's one addition here. We're all familiar with lump sum assessments levied against property. Those could either be paid in full or assumed by the buyer. There's also assessments which are being paid in installments. Those and have a known end date or a lump sum payment option. Those could be paid in full by the seller or prorated. And we've added a third one, which is assessments being paid in installments that do not have an end date or a lump sum payment option. Those will automatically be prorated as of the date of closing. the minor damage and major damage provisions. And these are important, and there's some important changes in here. The first important change under a minor damage, we have inserted that the seller will make those necessary repairs no later than X days before the closing date. Previously, this was just floating and the closing dates were extended. So what is minor damage? Minor damage is just not major damage, which is defined down here. When we look at major damage, if there is major damage found, the buyer has X days to terminate pursuant to O-3. And you can see the definition of major loss down below. Lauren, can you talk a little bit about this, the minor damage, why that's an automatic repair, and then why major damage gives the buyer the opportunity to terminate?
Right. So property is considered unique in that, the buyer is really focused on a particular piece of property and for their particular use. And for minor damage, the expectation is that the property remains the same as far as what the buyer expected to acquire. Where you have major damage or something substantive that impacts the use of the property, then the question arises whether what the buyer anticipated acquiring is really what they're able to acquire. So major loss or damage is something that falls in the latter part, where it's questionable as to whether the buyer should have the right to terminate because what they're acquiring isn't what they anticipated. The reason why we put in 5% of the purchase price is that it could be based upon different factors, but it's unknowable in any particular circumstance what the specific dollar amount should be, or what a specific provision that would impact and could be considered major. So if you have something that, for instance, impacts access or use substantively, then the question is whether there should be something else that's negotiated for a major loss or damage, and that's something that the buyer and the seller should consider when they're entering into the contract. We tried to come up with something that was more general, that could apply to any contract, and so we use 5%. It could be more, it could be less in that particular circumstance as to what the appropriate percentage should be, but 5% is something that we considered reasonable under the circumstances.
Okay, thank you. And I'll point out that 5% is the threshold in the existing PSA as well. These are two of my favorite sections. I don't know why, being a contract nerd, but bringing out the tenant matters, tenant leases, and estoppel certificates. Previously, the tenant leases paragraph was buried in this J2 provision, and the estoppel provision was also kind of buried in this long run-on term right here. But we've separated this out, starting with the tenant leases. So the seller will not enter into any new, existing, or change any leases after the that will extend beyond the closing date, or enter into any agreements that cannot be terminated upon 45 days notice. Sara, can you touch on that just a little bit, why that's important?
Sure. So this is important because at the point when the due diligence period has expired, the buyer's money has gone hard and the buyer is expecting to close at that point. So the buyer does not want the seller to enter into any new commitments or any substantive amendments or changes to any existing leases that the buyer will be stuck with after closing. And so that's why we've limited the seller's ability to take those actions without the prior written consent of the buyer, just to give the buyer a little bit more control over what they end up with after closing.
Sara, is this language similar to what you'd put into your custom PSAs?
Yeah, it's pretty similar. I think the concept is pretty much what we usually see, which is that there's a little bit of a different treatment prior to the expiration of the due diligence period, and then after the due diligence period, there are more restrictions on what the seller can do.
Okay, thank you for that. And then the estoppel certificates, again, we see seller will use commercially reasonable efforts, and delivery of such estoppel certificates shall not be a condition precedent to closing. Lauren, can you touch on this just a little bit? Why is it not precedent to closing to obtain these estoppel certificates?
Right. So it's customary to have estoppel certificates obtained closer to the closing date, not during the due diligence period. So similar to what was discussed before, is the expectation is that the buyer has already gone hard and is committed to acquiring the property. So if you don't get one or more estoppel certificates, depending on the how many leases you have, buyer has already gone through the effort of trying to get their financing and is getting ready to close. So the fact that you don't want the estoppel certificate to be something that terminates the contract, since at that point you're already essentially proceeding to closing. And to do that would impact what the parties had understood or agreed upon.
Yes. And Lauren, if it's a more complicated or maybe has a large anchor tenant, or there's financing, I understand when you do your custom PSAs, you will already draft the estoppel certificate and you might have different requirements.
Right. So it's important to understand, what you need the estoppel certificate for. If it's for something that is required for the buyer's financing, the lender may have a specific form or specific items that they're requiring be contained in the estoppel certificate. So it's good to make sure that the form itself is agreed upon between the parties. Otherwise, the seller could send up something very simple, whereas the buyer, for their financing or for their own purposes, needs something more comprehensive. So I'll often include a form that's attached and says it needs to be substantially in the form that's attached, but it's also dependent on the transaction itself. There may be only one tenant, or if it's a shopping center, there may be 50 tenants. And so, having one tenant, that estoppel will be much more important than 1 out of 50. So it depends on the circumstances, and that's usually what I will evaluate in determining the estoppel certificate provision that I include in my own personalized contract.
Okay. And as Sara said earlier, this is not a one size fits all, but this is a starting point, but it will bring up the conversation as far as that goes. Okay. On the phase 1 environmental assessment, this is a big change in comparison to what we have had. So if the property reveals recognized environmental conditions or RECs on the property, the buyer may terminate the PSA within X days from delivery of the report. Sara, can you touch a little bit on this and why this is important?
Sure. So some of the feedback we receive from folks who have worked with properties, especially industrial properties or other properties that may have environmental conditions, is that it was very common for the phase 1 environmental assessments to take quite a long time to prepare. And so often the buyer was receiving the phase 1 after the due diligence period had expired, and sometimes even very close to the closing date. And so in that case, the buyer would be stuck in a very difficult position because they no longer had a right to terminate or any other way to get out of the contract, even though this phase 1 had uncovered some, previously undisclosed or unknown REC or other condition that was just not something that the buyer had anticipated. And so here we thought it was reasonable to include this right to terminate for the buyer. And I think, this really provides certainty and gives both parties a heads up that if there is something in the phase 1 that warrants the buyer to have that right to terminate, the buyer will be able to, instead of getting into a situation where, the buyer essentially just refuses to close and then the parties are stuck in a dispute.
Yes. And Sara, could you give a few examples of common RECs that we find in Hawaii?
Sure. So sometimes you'll find an underground storage tank that was not previously known, whether that is an old gasoline or fuel tank. Sometimes if the property was used for, let's say, auto repair, there might be hydraulic lifts or related tanks underneath the hydraulic lifts. Other times it's just a soils issue where the soil is found to be contaminated in certain areas, or there was some kind of a release that was, that occurred a while ago, and so the coring samples that will be received, and usually a phase one doesn't involve actual digging or coring, but the phase one will reveal indicators that show that a phase two is warranted, or that further inspection of the property is warranted, just depending on the prior use of the property or historical reports that may have been uncovered with the Department of Health or elsewhere.
Great. Thank you. Thank you for that. Okay, the termination, dispute resolution, and other matters. This section has been completely redrafted. It's important for everybody, again, to go through this in detail. If you look at 01, you can just see by the size of it, the top box is the new one, 01, and the old version at the bottom. So let's just take a look at this in a moment. There's a couple of changes. Termination due to default. If buyer is in default, of course, they can bring an action for damages, but also the seller can retain the initial deposit and additional deposit. This is a change. Previously, it just said all additional deposits, and sometimes sellers were arguing that that meant the cash that had been deposited as well. Lauren, can you touch on this for just a moment? And these are two of the identified words that you had talked about earlier.
Right. So the idea for this provision is that we're trying to prevent having the parties proceed to litigation. So the clearer we can be on the language in it, the better, so that there's no dispute between the parties as to what's anticipated to be returned to the buyer. And so the idea here is, of course, that the initial deposit and the additional deposit are both intended to be returned to the buyer. I'm sorry, the opposite.
In this case, it's buyer default, yeah.
Buyer's default, both the initial deposit and the additional deposit are intended to be returned, paid to the seller and not released to the buyer. And so there's no question that maybe it's only the first deposit and not the second. The expectation is the buyer makes a deposit, and that's the money that's at risk and can be paid to the seller upon termination of the contract.
Great, thank you. In the second section now, if seller is in default, of course, they could, the buyer could seek specific performance. But this is a new section that's been added. You can terminate, the buyer could terminate the PSA and instruct escrow to return all deposits previously made by buyer. This was not something included in the previous one. It was silent as to what happened to the deposits. Sara, can you touch on this for a moment?
Sure. So like you said, the contract was silent before, so there was sometimes confusion or dispute between the parties about what was supposed to happen to those deposits. And oftentimes the parties would give escrow competing instructions, at which point the escrow company would basically say, look, we need we need a unified instruction from the parties before we can do anything, because the escrow company did not want to undertake liability of taking one side or the other. So we thought it was important here to give that specific instruction in the contract so that both parties are agreeing to it and jointly giving it as part of the termination provision.
Great, thank you. And then I note that despite all of those provisions, the foregoing provisions will not limit or preclude any other remedies available at law or in equity to either seller or buyer. Laura, can you touch on what that means?
Yeah, so the idea is that this provision is not intended to be all-inclusive. It's intended to try to just address what generally happens when there's a termination due to a default. But that doesn't mean in a particular circumstance that there wouldn't be other remedies available, for example, injunctive relief. And so we did not want to forestall those remedies because we don't know the particular transaction and what would be applicable, but we were trying to focus on trying to cover what generally happens, but also make sure that the parties still had their full rights to proceed with whatever remedies that they wanted to.
Okay, great, thank you. When we get to the 02 termination within a contingency period, just to reiterate that the termination needs to happen before the expiration of the time period, or that contingency will have been deemed waived. 03 is a new termination provision. It basically adds a little tail to the end of the termination provision, and you'll find this in the financing in the major damage sections, but it's something to be aware of. Again, it's come from the residential side and it's been used with good success. This entire section has been completely rewritten, and let's start with mediation. So buyer and seller agree in good faith to attempt to settle such disputes or claim by non-binding mediation. Sara, does it mean that the parties must enter into mediation if there is a dispute?
Yes, so here we do, this provision does require the parties to attempt to settle the dispute by non-binding mediation as a sort of intermediate step before proceeding to arbitration or litigation. And we thought it was important to require this step. It's also consistent with what you'll see in many litigation scenarios because the court will often order mediation for the parties before they can proceed.
Okay. And then on the arbitration, the parties are encouraged to consider arbitration. So, Sara, this is non-binding. Can you talk about why that's the case?
Correct. So the arbitration provision is not mandatory. It does not require the parties to use arbitration instead of litigation. And the reason for that is historically arbitration was seen as a form of alternate dispute resolution that was often cheaper and quicker for the parties. As time has gone on, we've seen arbitration become often more complicated and more costly to the point where some parties feel that litigation is actually a more efficient and more appropriate way to resolve the dispute. And so we did not want to require parties to use arbitration if that wasn't right for their transaction. But we did want to give it as an option for them to consider in case it would make more sense in their case, in their particular transaction, to use arbitration as an alternative to traditional litigation.
And is this common right now for the PSAs that you would prepare?
I think it is. And more and more, we're seeing parties ask us to not include a mandatory arbitration provision. They want the ability to kind of determine at the time the dispute occurs what they would like to do. And so we are seeing parties looking for that flexibility, with the understanding that sometimes arbitration is still a more appropriate form of alternate dispute resolution.
Lauren, how about for you? Similar when you're doing custom PSAs?
Yes, I think because the parties can always, anytime, agree to arbitrate. And so if there is agreement based upon what the dispute is, then they can agree to arbitrate. But ultimately, I think I've seen more litigation actions with respect to purchase contracts. The cost and the timing and trying to even just agree on an arbitrator can be sometimes very difficult between parties that are in dispute.
And I think our buddy Michael Carroll also felt the same way moving forward. This section has been completely redone, brokerage firm services, disclaimers, and indemnification. We're not going to go through all this, but important to see it all. Just want to stop here. Scope of service. This gives a whole laundry list of things that real estate agents and brokers do not do, cannot give advice on. Sara, can you touch on this for a moment and the importance of staying in the lane?
Right. So it's very important for many reasons to really stick within your own area of expertise. It protects not only the parties, the clients, but it also protects the brokers and agents from any, accusations of reliance on, let's say, legal advice that was given or engineering advice or opinions that could have been construed as, expert opinion. And so it's really important to just continue to provide that expert real estate brokerage advice and agency advice, but not to, purport to provide advice on any other topic for which you are not qualified or do not have that expertise. And again, it's to protect not just your clients, but also you as well.
Great. Thank you. Acceptance date. This has been cleaned up. So acceptance date means the date on which the PSA becomes binding upon the parties, i.e. fully executed and delivered in accordance with the terms of this PSA. Lauren, can you touch on that a little bit? What does it mean to have an acceptance date?
Yes, so an acceptance date, as it says, means the date it becomes binding on the parties. So that means that when the contract is enforceable, and to be considered enforceable, it needs to be signed and delivered by the parties. So just because there's an execution with a date on there doesn't mean that that's the date of acceptance. It's the actual delivery date that triggers when a contract is enforceable and when the parties are bound to it. So just make sure you're careful to ascertain when the actual delivery date was, rather than just what the date is that's reflected on the contract.
Yes, and in the previous version, it incorrectly stated when the parties signed. And I just want to point out that a day is a calendar day. And unlike the residential contract, the contingencies expire at 5 p.m. On the residential, they expire at 11:59 p.m. Just pointing that out for the brokers that straddle the two worlds. Okay, the assignment provision. So there's some language added here. One, a buyer can assign it to an entity in which buyer owns more than 50% or the ownership interest, or in which buyer holds or controls more than 50% of the management decision-making authority. Sara, can you explain why this is inserted in here and why this is important?
Sure. So we wanted to provide both sort of flavors of control or both scenarios, which we see commonly in modern transactions. Many transactions nowadays involve limited liability companies or limited partnerships in which there could be a party who has a very nominal ownership interest. They may only own 1% of the LLC membership interest or 1% as a general partner, but they have most of, if not, all of the management or decision-making authority to act on behalf of that entity. And so this is in the context of an assignment where the buyer can assign the PSA without the seller's consent. And so we wanted to provide sort of two scenarios for that assignment right. One, if the buyer is a majority owner in the actual equity of the assignee, or sorry, the assignee entity, or two, if the buyer effectively controls that entity through the management or decision-making authority that buyer owns, notwithstanding the actual ownership or equity interest in that entity.
Okay, great. Thank you. On the reps and warranties, so this has been retooled. And of course, this is not going to cover everything. But Lauren, can you just touch on the importance sometimes if it is a more complicated transaction, why you do need to have much further in-depth reps and warranties?
Yeah, so it depends on the circumstances, but here what we included are just those provisions that we felt were necessary to make sure that the parties can execute and perform the obligations under the contract, which is essentially to make it binding. If in reviewing or in evaluating the property, there are certain things that are important to buyer, those are the things that should be added in, either through a special terms addendum or some other on the list of additional add-ons to make sure that those issues that are important to buyer for a particular property are included. For example, if there are specific representations and warranties that the buyer wants with respect to tenant estoppels or tenant leases, if there are utility that are important, just a litany of usually focus on what the buyer is going to use the property for. Those are the things that the buyer may want to add with respect to reps and warranties, and then the seller, depending on if they have knowledge of those things, will be agreeable to adding.
Yeah. So just another good reason to make sure you've got good legal representation. Page 11 has been retooled to have all the information relating to the brokers, starting with agency disclosure, identification of the brokerage firms, and this is a brand new term that's been inserted. This is U2, seller's direct compensation to buyer's brokerage firm. Seller will pay buyer's brokerage firm through escrow at closing an amount of, and this would be the commissions. This replaces the previous T3, which talked about payments to seller's broker. The reason this is in here now, under the standard listing contract, there is no ability to pay commissions to buyer's brokerage firm through the listing broker. It must come direct from the seller. Now, this last sentence here designates buyer's brokerage firm as an intended third-party beneficiary having the right to enforce this paragraph. Sarah, can you touch a little bit on what that means to be an intended third-party beneficiary?
Yes, so typically the only parties who can enforce a contract are the parties who entered into that contract, in this case, the buyer and the seller. However, if the parties identify and express intended third-party beneficiary, that third-party beneficiary will have the right to enforce either the entire contract or a specific provision of the contract. So here, the buyer's brokerage firm is identified as an intended third-party beneficiary of just this paragraph U2, meaning that that buyer's brokerage firm will have the right to enforce that paragraph U2 as against the seller, who is obligated under this paragraph to pay that commission.
Okay, thank you. On the final page, which is our signatory page, we have an addenda section, not too much change there. We have the signature box for the sellers. We've removed all the personal information that was rarely completed anyway. We've added this notice of rejection, which is required under the Hawaii administrative rules. And then finally, we put a new reviewed by seller's brokerage firm box at the bottom of page 12. As principal broker, I'm very appreciative of this. I don't want my agents out there doing deals that I don't know about. So I think all the brokers will really appreciate that. And just quickly, the commercial counter offer has also been updated to reflect the changes. It's 2 pages, just lining up with the new purchase contract. And again, an addition of putting a signature box for the reviewing brokerage firm when that is received. So I just want to say to anybody who's watching this, if you are looking for a real estate attorney who is professional, responsive, and knowledgeable, these are 2 of the very best in town. I've had the chance to work with both of them. They are phenomenal. Sara, Lauren, want to thank you so much for your time on the committee, all your efforts on that, and for taking the time to be here today to share your insights and the background on that. So until next time, be well, be kind, and aloha.